Start. 18. It cannot be gainsaid that winding up of a company is a process in which the lifespan of it is cut short and its property administered for the benefit of its creditors, contributories, and the shareholders hyphen members by a competent person to be appointed by the court. Stop. Winding up of a company differs from the insolvency of an individual, in as much as a company cannot be made insolvent under the insolvency law in India, unlike in United Kingdom. Stop. Moreover, even a solvent company may be wound up and administered, or a liquidator could be appointed by the competent court who takes charge of the company and the company remains under his control. Stop. He collects its assets and dues and pays and debts and liabilities, and finally distributes any surplus amongst its members in accordance with the respective legal rights of the concerned parties. Stop. This is highlighted to show that once an order of winding up is recorded by the competent court on any one of the grounds enumerated in section 433 of the Companies Act, the outcome would be like the death of an individual. Stop. Once the winding up order is passed, the entire managerial functioning and decision making authority is shifted and ordinarily entrusted to the official liquidator or an administrator. Stop. No doubt, the impunged order radiates an imprint of only an admission of winding up petition and directing the publication of the advertisement in leading daily newspapers. Stop. It also cannot be gainsaid that an order admitting a winding up petition and the resultant order for the publication of an advertisement inviting claims from respective parties and by the company notice, in many cases, from the commercial point of view, the business point of view, from the markability point of view, no less injuries than winding up. Stop. This proposition could, hardly could be questioned. Stop. 19. The parameters prescribed or propounded by process of evaluation of case law, in order to reach the conclusion of a fit and appropriate case for declaring a company fit for winding up are also very well settled, extensively explored by a catena of judicial pronouncements. Stop. The expression in section 433 within bracket E is required to be considered and examined taking into account various aspects. Stop. It may also be mentioned at this stage, that a claim to an order of winding up is not a matter of right, but it is the discretion of the court on one or more of the grounds have been established as mentioned in section 433 of the Companies Act. Stop. Even at the stage of admitting the petition, unlike other petitions, the company code has to be very alive to the relevant aspects and is obliged to consider many aspects. Stop.